So after Congress eliminated the tax on certain NFA items, many gun owners celebrated, and many assumed that if the tax disappeared, the NFA might not survive for much longer. But now the federal government is fighting back. In a major new court filing, the DOJ has revealed exactly how it plans to keep the NFA alive, and its arguments could affect every major, currently developing case that is working its way through the courts. So let's break down what is now happening in this critical case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button that just tells the algorithm that you appreciate this content, and so it shares it with more people. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. So if you're interested, you can check them out and learn more about them using the links down below. And for a limited time, if you decide to sign up using my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off of the family sign-up fee. Now, as I mentioned in the intro, in this video, we're going to be discussing another major NFA challenge that is trying to build off the recent $0 tax changes that were passed by Congress. This case was filed in the Eastern District of Kentucky by a coalition of gun owners, firearms businesses, and then also 2A organizations, and they're challenging the NFA's remaining restrictions on suppressors, SBRs, SBSs, and AOWs. We've already discussed the major challenges filed by Silencer Shop, the Brown case, the Jensen case, and now this Roberts case has joined that growing list of NFA challenges. The basic argument from the challengers here in this case is really straightforward. They say that for decades, the federal government justified the NFA primarily as a tax statute. The Supreme Court upheld the NFA in cases because it was tied to Congress's taxing powers. But now that Congress has reduced many of those taxes to $0, the plaintiffs/challengers here argue that the constitutional foundation supporting those restrictions has largely disappeared. According to the challengers, if there is no meaningful tax left to collect, then there is no reason for the federal government to maintain the registration requirements, the approval requirements, the transfer restrictions, and all the criminal penalties attached to these regulations. And now we finally know how the federal government intends to defend the NFA going forward. The DOJ in this case is making three major arguments. First, the government says that the NFA is still supported by Congress's taxing powers. The DOJ points out that while Congress reduced the making and transfer taxes on suppressors, SBRs, SBSs, and AOWs to $0, it did not eliminate every NFA tax attached to that statute. They state that importers, manufacturers, and dealers of NFA firearms still have to pay that special occupational tax. And according to the government, the registration and approval requirements help to enforce and collect those remaining taxes. So in other words, the DOJ argues that because some NFA taxes still exist, Congress still has the authority to maintain the broader regulatory framework and keep this going forward. But that's only the beginning of their arguments. Their second main argument is essentially that even if the taxing power were insufficient, if it was invalid, Congress can regulate suppressors and short-barreled rifles through the Commerce Clause. According to the DOJ brief, suppressors, SBRs, dealers, manufacturers, distributors, and purchasers all participate in a national interstate firearms market. Because those items move through interstate commerce, the government argues that Congress can regulate them regardless of what happens to the tax stamp. Even though it went to $0, they claim that these items still cross state lines, they go interstate, and therefore can still be regulated under the Commerce Clause. This is an extremely important argument because it signals that the government is preparing for a future where courts may become very skeptical of relying solely on the taxing power. If the tax argument actually weakens, the DOJ wants the Commerce Clause available as a backup justification for the NFA. And if courts accept that theory, it could dramatically change how the future of these NFA challenges, move forward and how they're actually litigated. The government's third argument is that even if portions of the NFA do not directly raise revenue or directly regulate interstate commerce, Congress can still keep those provisions in place because they are necessary and proper to enforce the broader regulatory and statutory scheme. Essentially, the DOJ is arguing that the registration system, the approval process, the criminal penalties, that they all work together as part of a larger regulatory structure. Therefore, even if one piece changes or maybe even goes away, they can keep the rest and the rest can survive. However, this case, Roberts, is not just about congressional power. The plaintiffs are also making a direct Second Amendment challenge to the NFA. And here the government relies heavily on historical arguments that we've seen in other NFA cases as well. The DOJ argues that these SBRs and SBSs have historically been treated differently because they are concealable and allegedly associated with criminal misuse. The government also points to recent appellate decisions that have upheld restrictions involving NFA regulated items. The challengers, of course, argue exactly the opposite. They contend that suppressors and SBRs are commonly owned by law-abiding Americans for lawful purposes, and that there is no historical tradition or justification that really supports this type of federal registration scheme and this whole permission slip system that these items are now under. That issue will likely become one of the central battlegrounds of litigation moving forward and will be a critical component to this case as it develops. Now, what makes Roberts so important isn't necessarily the plaintiff's arguments. We've seen many of these arguments before, but what makes this case important is that we now have the federal government's complete blueprint for how they plan to defend the NFA going forward after this, post-tax stamp reduction from $200 to $0. And that blueprint will likely show up in every major NFA lawsuit moving forward. The federal government has now officially told the courts, even if the transfer tax is gone, the NFA survives because of the taxing power, the Commerce Clause, the Necessary and Proper Clause, and historical regulations and justifications for these types of items. Whether these courts ultimately accept those arguments remains to be seen, but this filing gives us perhaps the clearest picture yet of how the DOJ and how the federal government plans to defend the NFA in this post-$0 tax world. So that's the latest update in this NFA challenge after the $0 tax. This is the Roberts versus the ATF case. This is a new challenge that has been filed in federal courts. It's in Kentucky. And the federal government has now revealed the legal roadmap that it intends to use to defend the NFA after the $0 tax change. So as this case develops, as the court begins to, develop these issues and request more information, not just in this Roberts case, the Brown case, the Jensen case, and the Silencer Shop litigation as well, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.